As an employer, how can you safeguard your business from unfair competition and enforce exclusivity clauses? In this video, I'm going to tell all. My name's Jennifer, I'm the founder of Silk Helix, and we help small businesses with all things HR, employment law, and people management. What are exclusivity clauses? They are clauses either within a contract or a restrictive covenant which states that somebody cannot work for either another employer altogether, for the competition, either during employment, sometimes after employment, and they may be as restrictive as you cannot do any work, either paid or unpaid, outside of your employment, or they can be less restrictive with you can work elsewhere with the written permission of your employer, which will not be unreasonably withheld. And we'll talk a bit more about what that means and where you might want to withhold consent and where you might not in an exclusivity clause. In the current environment where we're seeing an increase in second jobs, side hustles, these clauses are becoming more and more important as people are looking to supplement their income to manage increases in costs of living. And fundamentally, there's not a huge problem with people doing this as long as it doesn't impact the initial work that they do. And in some industries, that's going to impact far greater than others. Particularly in service industries where the service delivered by an individual really makes a difference to what the service is being delivered. So hair and beauty, solicitors, accountants, consultants, all of these are where the individual matters. And in these cases, exclusivity clauses to stop people working for the competition is really important. To give an example, we've actually had clients in the past where employees have taken days off, particularly in hair and beauty, taken days off and been working in the salon down the road. It doesn't take long for customers to realise that that individual is available doing the same services effectively in both salons, and the next thing we know, there's a price war and customers are just going to the cheapest. It's not good for business to allow that to happen. If people are working for you in those industries and they are crucial to the delivery, I would absolutely be recommending that you ban working for the competition or in any form of competition, including any work that you do for yourself, in order to protect the business. There'll be many other cases as well where you don't want people working for the competition, even where they're not in these service delivery roles, where people have information that can be taken. There's a lot of reasons why you wouldn't want somebody working directly for a competitor whilst they work for you. And indeed, sometimes for a period of time afterwards, or you want to restrict them from taking customers or clients. And these restrictions are about protecting the business. So you're only allowed to go as far as you need in order to protect the business, particularly after somebody has been employed. An employment tribunal is going to expect that they will be able to earn a living, that they're not stopped from working, and that the business will only go as far as it needs to protect itself. We're in a time where increasingly we're seeing people take on second jobs or side hustles in order to meet the demands of increasing costs of living. And therefore, as an employer, you don't necessarily want to say no to that if it's a way of keeping people employed and actually it's a benefit to them. In addition, they're likely to be learning skills in those roles that could potentially come back and help them in their original role. But we do need to think about the business and whether or not this is going to do any harm to either them or to the business. So when it comes to exclusivity clauses, we've got this wide variety in that we can be saying there is no work that you can do outside of your employment with us, whether it's paid or unpaid. That's the extreme. The other end, which we tend to be recommended in most situations when we're working with clients to build employment contracts for them, would be that you can work elsewhere, but you need to have the written permission of your employer and it cannot be in competition. Now, the really extreme one of no paid or unpaid work is very extreme, and there's not going to be many cases where that's reasonable, particularly unpaid work. So many people take on volunteer roles, and again, they're advantageous to the business. People learn skills in those roles. They give people a sense of purpose in their life. There's all sorts of benefits of people taking on volunteer roles, and therefore, very rarely is a business going to need to ban those. People working with written permission, though, is much more sensible and allows you to make decisions on a case-by-case basis. Let's say, for example, somebody's doing a day job 9 to 5 in an office and then they take on a night shift somewhere else. The problem with that is they're not getting a decent break overnight. There's issues with the working time regulations. They're not getting their 11 hours in a 24-hour period. They're going to be exhausted. It's going to impact their performance in the day job. Not many people will be able to maintain that level of work for very long. That said, if somebody's doing 9 to 5 Monday to Friday and then one shift in a pub on a Friday evening, it's going to be much harder for an employer to reasonably say, no, you can't do that, especially when there's no competition issues and they've got 2 days over the weekend to recover before coming back to their original job on a Monday. So when we come to exclusivity clauses, it is about being reasonable, it's about being fair, and it's about what you need to do to protect your business. And absolutely, as an employer, there are things you need to do to protect your business. Preventing people working for the competition is definitely one of them. It's definitely something that we recommend to all of our clients to include in their contracts. And if you want to work with us to do your employment contracts, there is a link in the description below on how you can get in touch with us. Having said all this, there are a couple of situations where exclusivity clauses are banned. So in 2015, it was made law that you could not put an exclusivity clause into a 0-hour contract and enforce it. So if somebody's got 0 hours with you, then you cannot enforce a exclusivity clause. They will be able to work wherever they want, whenever they want. That was extended in December 2022 to those who are earning lower than the lower earnings limit for national insurance contributions. Again, in these situations, you cannot enforce exclusivity clauses. So if you've got people that are only working for you occasionally or very low hours, then you may find that they fall into these categories where you cannot enforce exclusivity clauses. And it may be that if you're in industries where working in competition is highly problematic, like the cases I've described, that you may need to rethink whether 0 hours or very small numbers of hours a week are beneficial to your business, and whether you need to rethink how you employ people to avoid being stuck with somebody who is also working for your competitor down the road, or maybe even working privately and sucking clients out of your business. We've seen it happen. Don't let it happen to your business. So what would you do if somebody breached an exclusivity clause? Well, if they're an existing employee, you'd be using the disciplinary procedure. If they're a former employee, you'll be writing to them to remind them of the clauses that they signed. You'll be asking them to desist from what they are doing that is in breach, and you may be looking to go to court for an injunction. In either of those situations, do take detailed advice, because that's a very short description of very detailed processes. If you do want to get advice from us, there's details in the description below on how you can get in touch.